Hey everyone, welcome back to our channel. Today we're diving into one of the most controversial trends at the US Supreme Court, the shadow docket. Now I know what you might be thinking, what on earth is a shadow docket? Is it some secret club for justices? Well, not quite. The shadow docket refers to emergency or summary orders from the Supreme Court, rulings made outside the court's ordinary merits process. These orders often come without full briefing, sometimes without oral argument, and usually on an accelerated timeline. They can be short, unsigned, and yet they carry real legal effect. Historically, these types of rulings were reserved for procedural matters, last-minute stays in death penalty cases, or time-sensitive disputes where delay would cause irreparable harm. The justices have always had the legal authority to issue such orders, but traditionally they were used sparingly, while the court emphasized the importance of its full merits docket with detailed opinions. Fast forward to today, and the story looks very different. The number of cases decided through the shadow docket has risen sharply. In the 2023-24 term, there were 44 matters on the emergency docket. And since Trump came into his second term through June of 2025, that number shot up to 113. This is far above the historic average, when only a handful of such rulings would come down each year, usually with limited significance. Now the shadow docket is being used to decide big-ticket questions: immigration, executive power, social policy, the kind of issues that in past decades would have gone through full briefing and oral argument. And here's where it gets really interesting. Reuters recently reported that in 25 emergency applications filed by the Trump administration this year, the Supreme Court acted on 24 of them and sided with Trump, at least in part, in 21. That kind of win rate on the shadow docket stands out. Lower court judges, appointed by both parties, have voiced frustration. The orders are short, often unexplained, and leave them guessing about what exactly the Supreme Court expects. Justice Elena Kagan has warned that heavy reliance on the shadow docket undermines the court's ability to do its best work, while Justice Neil Gorsuch, sometimes joined by Justice Kavanaugh, has argued that even these summary orders carry precedential weight. So does greater use of the shadow docket automatically equal bias? Not necessarily. The rise in emergency rulings may partly reflect how contentious today's politics are, with more litigants rushing to the court for immediate relief. But the pattern of outcomes does raise eyebrows. Historically, the shadow docket wasn't used to consistently favor one party or administration. Now, the frequency and direction of the rulings suggest a structural lean in favor of certain positions, particularly those advanced by the current Republican administration. This isn't just a procedural quirk. These orders are shaping national policy without the transparency of full opinions. And the more the court uses the shadow docket for politically charged cases, the more it risks undermining public confidence in its fairness and neutrality. Whether that's intentional bias or simply a byproduct of the court's view of emergencies is still open to debate. But the evidence points to a major shift in practice compared to the historical norm. One thing is clear. While the shadow docket isn't new, but how it's being used today is unprecedented. It's not just about what happens behind closed doors, it's about how law is made in real time, how precedent is shaped, and who benefits from these decisions. Thanks for watching. If you found this breakdown useful, hit like, subscribe, and ring the bell for more deep dives into the Supreme Court and the future of American law. Until next time, stay curious